This video is going to quickly go over loss of consortium using our Miller case. Let's begin with determining whether loss of consortium is a tort or a remedy, especially because we've just discussed wrongful death and survival acts. Loss of consortium is actually a remedy. Loss of consortium can arise from either the intentional or negligent conduct of a third party toward a marital relationship. So loss of consortium is often a remedy awarded for the wrongful death or the injury of a spouse. What actually is consortium? What falls under loss of consortium? Well, there are many different definitions, but generally it's the mutual right of the husband and wife to that affection, solace, comfort, companionship, etc., pretty much any emotional or intangible elements of a marital relationship. When analyzing this on exam, step one will usually be whether you were successful on the underlying intentional, negligent, or wrongful death claim. The step two issue is, well, how do we measure loss of consortium damages? Because they seem similar to emotional distress, pain, and suffering, where they're very squishy and hard to measure. Court determined that the jurors must be expected to act reasonably, intelligently, and in harmony with the evidence. So very broadly, a reasonable standard view of determining what was lost due to this spouse's death or injury. In our case that we read, we had a defendant and the husband were in a car accident. Now, the husband released the defendant from liability for consideration of almost $10,000. So they had a settlement. But the wife did not enter a settlement with the defendant and sued the defendant for loss of consortium, alleging the negligence caused injury to her husband. The issue before the court is, if the impaired spouse has recovered for his or her damages, is the deprived spouse precluded from suing for loss of consortium? So because the husband settled for 10K, does that preclude the wife from suing the defendant for loss of consortium? The court answered no, because each spouse suffers a separate and distinct injury. So allowing the spouse that wasn't impaired, who hasn't recovered, to now sue for loss of consortium doesn't actually create a double recovery, even though the impaired spouse has recovered for her damages, because they're two different people with two different injuries. The impaired spouse covers for bodily injuries, medical expenses, pain and suffering, lost earnings. So that's the mental anguish, physical pain, and lost earnings. The deprived spouse, which is the other person who's not injured, they suffer from intangible and sentimental elements. Loss of consortium can include loss of companionship, emotional support, love, sexual relations, real and direct personal losses. And so why does this loss of consortium exist as a remedy in our legal system? Our legal system believes in protecting the emotional interests of a marital relationship. We believe those are just as important as negligent invasion of other protected interests, such as property and personal injury. But this case also discussed the history of loss of consortium, because it was only limited to men. It was only in 1953 where the wife's cause of action in the United States was recognized, because this case occurred in 1978 and the opinion mentioned it was only 25 years ago. And that has to do with the gender inequality that existed in, or still exists in, our legal system. In fact, women had no property rights until the mid 1800s. They couldn't even sue or be sued or hold property. And so the recognition of women being able to have some sort of interest in a marital relationship is actually fairly new. It's only about 50 plus years ago. But you can see we continue to explore these issues and the law continues to change with the times.